And thank you very much for being part of the symposium, Liliana, and obviously to always be there to translate and help all people in Spanish. So I really thank you a lot for that. And of course, you've been around. You have to introduce yourself. You have to take it forward. And then from there, I'll come in whenever you ask me to come in. Please.
Okay. So hello to everyone. First of all, thank you so much, Vikram, for inviting me as a speaker in this symposium where so many amazing people have talked about mediation in the world. So many much more experienced people than I am. So I feel really very privileged and honored to be able to share this panel with all of them. And it's not a problem. I am really happy to have helped with the translation and to be able to assist all fellow mediators around the world. So thank you again, and thank you all for being there, listening, taking time to listen just a bit, talk about mediation. So as Vikram said, I am Liliana Amione. I am from Argentina. I would like to share my screen. Can I do that, right? Perfect. So just a minute.
But you'll have to introduce yourself, Liliana. A little bit about yourself, yeah.
Okay, yes. I wanted to share the screen because I have the location of my city, and also, well, I am a mediator and as well as an attorney, and I live in a city called Rafaela, which is located within the province of Santa Fe in Argentina. Santa Fe is on the central eastern part of the country of Argentina. My city has over 100,000 inhabitants, and it's the third most important city in the province of Santa Fe. So, as I said, I am a mediator. I wanted to show you the location of, Argentina in the American continent. So it's part of the South American continent. So this is Argentina. And this province, Santa Fe, which is the shape of a boot, that's how we identify it. So there is my city, Rafaela. So in the center west part of the province. So I am a mediator since 2017. So I'm a recent mediator. So in terms of time, I have been in touch with mediation recently. I am part of a roster from the Ministry of Government, Justice, Human Rights, and Diversity of the province of Santa Fe in Argentina. But as Vikram pointed out in this symposium, so mediation is something that some people probably are born with, and some other people, it's something that at least at some point in your life you have done among your friends, your family, your co-workers. So the idea of the symposium, the concept that was proposed, it's really appealing, at least for me. It made me wonder about historical human interactions, social interactions. And of course, I am not able to picture that historical interaction in a full extent about Argentinian human interactions, but I am going to refer to the current situation in terms of mediation in my province and especially in my city. So my presentation is going to be about a little bit about the legal framework at the national and provincial level, then a comment on the current state of mediation in the province of Santa Fe, and then some ways to promote what I think in a humble way, what I suggest or what I reflect and debate about how to ensure mediation is well known among citizenship to achieve its sustainability, because that's what I found most important, that people are not yet familiar accurately about mediation. So I wanted to show this, the location, because as you saw here, so Argentina is divided into provinces. And it is important to state that Argentina is a federal state. The system of government is representative, Republican, and federal, according to the national constitution. So it's territorially organized in provinces. The country is divided into 24 jurisdictions, 23 are provinces and 1 federal district. And as a federal system, there are 2 orders of territorial power, and they have a difference. They distributed the competences, between the federated states and the central state that we call national state. So this is important to clarify as a preliminary comment, because in terms of mediation, the provincial states are autonomous. So each province has adopted a different system in terms of ADR, in this case of mediation. So at the national state, the background, Argentina started to have a global vision of ADR, the ADR movement and its benefits in the 90s, since the 90s. So in 1991, a mediation commission was created by the resolution of the former Ministry of Justice. Now it's called Nations Ministry of Justice and Human Rights. This mediation commission was the first one, and it was integrated by remarkable judges, attorneys, and academics. And it was tasked with the design of a national plan of mediation, and also with the drafting of a mediation law bill. And it also, that commission pointed out the need to implement a pilot experience on mediation within some civil courts. That all that work led to the passing of the national decree number 1482 of in 1992. That in that national decree, that it was the first law in on mediation. It was declared of national interest the institutionalization and development of mediation as a non-adversarial method of conflict resolution. And that national decree also collected all the suggestions made by the Mediation Commission. So it ordered the mediation pilot experience, that it was ordered by that resolution 983 in 1993. So this national decree, it is recognized as the first step on which the development of ADR methods in the country was based. Also, the pilot experience in 1993, and from that law, from the national decree, the first mediation center was created in the orbit of the Ministry of Justice. So it depends on the judiciary, the judicial power. That program continued until October 2005, when the mediation law was passed. So the main reason for having a mediation law back then to support, the passing of the mediation bill in 1995 was the situation of the justice, the emergency, the crisis, the overcrowded justice system that was in danger. So that is why in 1994, the executive power presented a draft law of a mandatory pretrial mediation. And in the message to the nation's Congress, here I put this because I found it interesting. It says that the situation of notorious crisis in which justice is found justifies the introduction of solutions that seek respond to this emergency. Through those measures, an attempt is made to reduce the high level of litigation that our courts currently suffer. At the same time, it tries to provoke a greater speed in the solution of the issues that must be judicially resolved, since part of the great mass of trials that crowd the courts will be diverted by means of this method, of these alternative methods. So this was, the main reason, or the reasons given to support a mediation law back then in 1995. So law number 24,573, Mediation and Conciliation Law, which established a mandatory pretrial mediation, passed on October 1995 and had a validity of 5 years. So that validity was extended for another 5 years in 2000, and again in 2006, and lastly in 2008. Because on May of 2010, the law on mediation and conciliation number 26,589, it was passed and is currently in force. So this law incorporated definitely incorporated mediation and conciliation into the civil and commercial procedural code of the nation. So that gave more force or reinforced mediation as a tool for, we use the word here that is dejudicialization, that is actually had not a corresponding translation in English, but I think you understand what that means. If a judicial case is turned into courts for resolving conflicts, so dejudicialization, is like the negative form is outside the courts. So that's why we talk about dejudicialization of conflicts. So that law at the national level that introduced mediation into the civil and commercial procedural code of the nation gave much more force to mediation as a tool for solving interpersonal conflicts outside the courts. So, and also allowed the expansion of this institute to other areas, such as community, school, and penitentiary. And also the message to that law is, it's important to highlight, because in the message of elevation, the executive power to the nation's Congress, it was recognized that the validity of the former law, the previous law, and its extensions meant, in addition to an appreciable discharge of legal cases, a bet on the self-composition of the conflict, with the consequent saving of time, money, and efforts by those involved. So these are, like, in a national level, the background of the legal framework. In my province, which I said is Santa Fe, there's important to first clarify that there are two models of access to mediation that coexist. One is provided by the Mediation Management Agency that depends on the executive power, and the mediation centers of the judicial power. So first of all, mediation in the judiciary, the judicial power of Santa Fe since April 2017 has two mediation offices, one in Santa Fe and the other in Rosario, which is another city in the province. those mediation offices administer and coordinate the service, both in a preliminary ruling and intrajudicial instance, and on civil and criminal areas. The judicial mediation began like a pilot program that was organized by the Supreme Court of the province in 1995. And then in 1995, in August 1995, that agreement of the Supreme Court of Justice, the Act number 30, established and regulated judicial mediation as a voluntary and free process. Another thing to have in mind is that law number 13,178 created the jurisdiction of the community justice of small causes, and that introduced an instance of judicial mediations by these judges that address small cases, small claims that have a certain amount of money. You know, they just they do not have competence in all sorts of conflicts, just only in certain cases until certain amount of money, you know, just small cases. And they have to refer the case to a public and free mediation center. And if they cannot do that because there's not a mediation center nearby, they are allowed to act as conciliators itself. So the other way to access mediation in the province is mandatory mediation prior to trial. And the legal framework is the law number 13,151 of mediation that was passed on November 2010. And it established the mediation system as a non-adversarial method for the desjudicialization of dispute resolution throughout the province as a prior and mandatory instance before accessing courts. That legislation has been regulated by provincial decrees in 2011, 2014, 2018, and lastly in 2019. The implementing authority of the compulsory pretrial mediation system is the mediation management agencies within the scope of the Undersecretariat for Access to Justice of the Ministry of Government, Justice, Human Rights, and Diversity of the province of Santa Fe. The mediation procedure is mainly structured on the physical presence of the parties and the registration on paper of the actions linked to its development. However, during the process, there are certain stages that can be identified where ICT, it has been incorporated. For example, the initial form to request a mediation is sent electronically. The draw of the mediator is as well being made electronically. The notification of said designation to the applicant and the mediator is through the digital system, and well as the digital preparation of the records of the mediation. So that work scheme, like it happened worldwide, it was suspended because of the emergency generated by COVID-19 outbreak, which involved, of course, the preventive and mandatory isolation and social distancing throughout the Argentine territory to reduce the risk of contagion and prevent the spread of the virus. So in that context, it was necessary to ensure the uninterrupted provision of the compulsory pretrial mediation system during the duration of the health emergency, you know, considering the impossibility of its execution according to the legally regulated process that is personal and face-to-face. So for that reason, resolution number 5 on May 2020 established the possibility to hold meetings, mediation meetings by electronic means, by video conference or other similar means of transmitting voice or image. in mediations whose number of participants is greater than 5 people, including the mediator. So in such cases, the obligation to participate by personal appearance is exempted. In cases of mediations in which the total number of participants does not exceed 5 people, including the mediator, the meetings were allowed to be held in person, of course, with all the protocols, safety protocols and prevention. But it was allowed to make it in a non-face-to-face manner at the option of the mediator, and the mediator had to have the consent of the parties. So finally, the mediators were exempt from the obligation to submit printed copies of the records. But it was stated that this exemption only applies for the duration of the preventive, social, and compulsory isolation. So I have like some statistics to share that I think it could be important, that they were provided to me generously by the Undersecretariat of Access to Justice of the Ministry. So those are the numbers of mediations in the province. You know, these are the headquarters. The principal ones are 5. So Santa Fe, which is the capital of the province, Rosario, which is the 2nd largest city, and Rafaela, that I said, that is the 3rd. Reconquista and Venado Tuerto, those are the 5 headquarters. And there you can see mediations, the total mediations that were requested. This report covers from January to November of 2020. And the cut was made on November because it was presented on December. And something to clarify is that here mediations, the cases can have economic content or not. And over there, you can see in that chart that mediations have been organized, the ones that are finalized with agreement and without agreement. But something to clarify is that the ones without agreement, the system, the software, the computer system comprehends or includes in the non-agreement mediations, the ones where the parties did not assist, did not present it, did not come to the mediation. So it doesn't mean that they do not reach an agreement. So that's something to bear in mind, because the numbers, are a bit high in the non-agreement part. So that's about the legal framework, and something that I wanted to comment on the current status of mediation in the province of Santa Fe. That besides all the developments and the regulations and the ways of work, and that the management agency, in the case of the executive power of the province, has helped to keep mediation going in COVID context, acting really fast, providing a regulatory framework for that, even though, of course, that resolution number 5 that I mentioned generated a lot of doubts and insecurities and concerns about how to actually carry out that resolution, that mediation meetings in a virtual way during the pandemic. But they acted a bit fast and in an immediate way, and they provided us, the mediators, with a tool to be able to keep going with mediation. So, and all the principles, that all those concerns were addressed in a work table, we call it, between all the mediation centers from the association bars of the province and the Ministry of Justice of the province, and all the mediators. We gathered to set to clarify all those aspects and being able to work in a uniform manner. So recently, there was a bill, proposed a draft bill to modify the current mediation law in the province. And the reasons that explain that proposal had the clear intention to restrict the scope of application of mediation, to make it harder to practice, and ultimately to make it disappear. That was the purpose of that bill. So that reflects a lack of knowledge of the mediation and its benefits. And there's still, as we have discussed during this symposium, there's still a lot of prejudice among not only lawyers. I put that there because in this mediation bill, it was very clear. But it's the lack of knowledge of the fundamental elements that constitute mediation. For example, is this distinctive note as a voluntary process, because in that bill, it was stated that people were obligated to go to mediation because the system is mandatory, and that is kind of confusing to understand. So mediation is still resisted. Mediators are also dissatisfied, sometimes not motivated, because they do not see their role legitimized, by the community, by fellow attorneys. And the good thing that come up of this bill to modify the current mediation law, I am not saying that the mediation law does not need some adjustments, but not that one that was proposed, because the goal was to make it disappear. So mediators around the province, they really mobilized to promote mediation. A lot of debates and reflections started. So it was like we were a bit asleep, and we woke up to defend and promote mediation, because it was really a huge step backwards if that bill was passed. So in my city, there is a mediation institute within the Bar Association, and we have issued a document concerning that mediation bill, and we suggested the required improvements to the current mediation system. And that happened all over the province. And well, hopefully that mediation bill is not going to be passed as it was proposed. So that's something good that come up with that situation. So some comments regarding the promotion of ways and means to ensure mediation is well known among citizens. So why am I saying that well known among citizens? We all agree that mediation is an essential tool for peace building. We recognize that mediation broadens effective legal protection through new ways of access to justice. It is an alternative. I prefer an appropriate dispute resolution. I prefer to speak about mediation as an appropriate rather than alternative dispute resolution procedure, which reduces times, cost, increases effectiveness in both adhering, to the procedure and the agreement. Of course, it prevents lawsuits and decompress courts. It has the ability to decongest or decompress the court's workload. And it's also effective in the social relationship because it favors real and early negotiations and increase interaction, modifies the way of addressing differences, of seeing one another, encourages conversation and dialogue, and it has a pedagogical function towards social pacification because it motivates people to get involved to proper management of their own conflicts. So we all agree that mediation is that essential tool for peace building and all those benefits. And despite all those developments, interestingly, people are still not familiar with mediation and its benefits. But more importantly, people do not ask for mediation, do not seek on their own in an independent way for mediation. It is not yet perceived as a need. It is not offered by attorneys. And when that happens, it is because it is a prior requirement that must be met. And it's not taught as part of the university's curriculum, at least not in all the universities around the country, that will make a new model of justice lawyer, for example. But I'm not saying that it just has to be taught in that career. But besides that interestingly, people are not still familiar with mediation, even though all those developments that we have talked about. On the contrary, people are also not satisfied with the system of justice, which is perceived as slow, expensive, complex, discredited, or even inaccessible. So it is quite contradictory that even though that is the general perception, the presumption that courts are the principal forum for dispute resolution, it is still there. And of course, justice must still be there and must function in a proper way. But the two systems should coexist peacefully, as we are stating about one of the benefits of mediation. So whether courts actually are delivering a positive experience of justice, that is something that of course has been challenging. And that is what I wanted to show with all the messages of the projects of law of 1995, that back then it was recognized that the justice was not delivering a good experience of justice, and that was challenging. So that is why mediation was so important. So that presumption, of course, that courts are still the principal forum for dispute resolution is being eroded, and it will continue to be eroded because of the significant growth of mediation over the past few years, and because there is this general consensus about its fundamentals and benefits, not only to decompress the core workload, but also because of the amazing aptitude of mediation to empower the community to be the principal character in solving their conflicts, generating commitment towards that, making people own, appropriate the learning process, make them involved in certain equitable and sustainable agreements, empowering citizens in being able to address their own matters in an amicable way. And that preserves relations and that contributes directly in peace building. It is interesting that mediation allows people's or foster people's autonomy, in the way that mediation, we said, allows people to think for themselves, to come up with their own solutions. So it favors dialogue, and that autonomy is expressed in the ability and willingness to think, to choose, to act independently, and that is associated with authenticity, or at least I see it that way. And that made me wonder, that made me remind that essay of Immanuel Kant's An Answer to the Question, What is Enlightenment, of 1784. And I want to share that phrase, that the beginning of the essay that said, enlightenment is man's emergence from his self-imposed nonage, knowledge is the inability to use one's own understanding without another's guidance. This knowledge is self-imposed if its cause lies not in lack of understanding, but in indecision and lack of courage to use one's own mind without another's guidance. Dare to know, sapere aude, have the courage to use your own understanding, is therefore the motto of the Enlightenment. I found it really nice that the beginning of that essay, because it's so challenging what he is saying. And I found a link to Mediation's goal to empower people to be able to address their own conflicts and come up with their own solutions, thinking by themselves, choosing, acting on without authenticity, with willingness, and not expect a third person to decide for them. So I wanted to share that with you. So of course, for mediation to be sustainable, it's still necessary to raise awareness to be able to talk about the positive of mediation. Without that awareness, the citizens do not reach to mediation, do not even know that it's a possibility, a real and actual possibility to access justice. That is another aspect, because mediation is related directly to access to justice. To actually, there's a paradigm that is broader about access to justice, and to actually solve their conflict in a more realistic way, closer to real life. So efforts should be made to spread knowledge about mediation, debate, and expand mediation, as you are doing, Vikram, in this symposium. So it can be known throughout the community and within the framework of the promotion of access to justice. That, of course, should be accompanied with a good practice by good operators that are committed to the process, that have a strong conviction on mediation and its value for society. And of course, public policies that encourages the system to ultimately establish a voluntary rather than mandatory rights-based mediation process. For example, here in Argentina, there is a crucial aspect to overcome, that is the state resistance to solve issues through mediation. So in this country, at least, it is the most defendant subject, the one that generates the most litigation, and also it closes doors to any negotiation. It is like a culture. And the truth is, there are no reasons why conflicts in which the state, either as plaintiff or defendant, are excluded from mediation process. So, and having more effective ways of resolving disputes is indispensable for building citizenship and ensure a culture of peace and human development. So, final thoughts, I wanted to highlight that the value of mediation as an efficient and cost-effective dispute settlement mechanism has gained formal international recognition with the adoption of the Singapore Convention on the Global State. So it is internationally recognized value of mediation, and as an important means for the peaceful settlement of disputes and conflicts, and it has proven to be an effective instrument to address both interstate and intrastate conflicts. And because of its significant benefits, it can be used for solving a wide range of disputes in various fields. Also, that it has become paramount to foster effective and efficient dispute resolution systems, including those which implement information and communication technologies, which we refer as to ODR, online dispute resolution, that had experienced a substantial proliferation and promotion due to the present global health emergency, and has become an effective, efficient, and preferred alternative for access to justice. And something that I found very important to bear in mind is that for me, the way I see it, a strong conviction on the value of mediation as appropriate or even proportionate dispute resolution rather than alternative is the base for an effective promotion of mediation to accurately disseminate its importance in preserving peace among citizens and operators of the legal system, and raise the necessary awareness to make people rely on it and carrying it out from generations. So that is all I had to share with you. Thank you so much for listening and for taking the time to reflect on mediation around the world.
Thank you, Liliana, for a very nice presentation. But let me first tell you that Virginia Dagoto is online and she says, excellent, congratulations. So you can thank her.
Gracias, Virginia. She's a friend.
I can see that. So that is important that people at least are watching and commenting, which they're interacting. I like that. But now you are speaker number 90. So now you've gone through, so you've seen sessions, you've been around, so you know my questions. So before I even ask questions, you can even answer them before I ask them, the way I look at it.
Yes. I know what you're going to ask me. Okay. So first of all, you're going to ask about indigenous communities or rural communities. And I'm not, I am so sorry about that, but I am not quite familiar with that process. And I live in a part of the country where, of course, there are indigenous communities, but they are not that populated. How can I say that? So I haven't had that experience, but I know because of speaking with other people that works on the area, that is the same thing that other speakers have comment on it. So you need to address the leader or have certain people that work among those communities to be able to enter to them. So, and they probably work their issues within the community. They probably do not take it outside the community, but it is not something that I am quite familiar with. So I can promise that I probably could do some research on it, but for another talk.
Okay.
And another thing that you're going to ask me is about the historical aspects, and that's what I said at the beginning of my presentation, that I'm not capable of picturing, like an accurate historical development. But what I can say is that in Argentina, there were certain figures of authority, within the community and the families. And that is the way probably they solve their issues. And this I know because of speaking with my parents, with friends. For example, the former peace judges, they had like a huge authority among small villages, small towns. Also, the notary, the public notary, they had a huge authority as well. And among families, and Giovanni probably is going to feel related to this, the father of the family, probably the grandfather or the great grandfather, had a huge authority, and people turn to that figure of authority and wisdom within the family to solve conflicts, at least within the family or probably with neighbors. So that is what I can say about how Argentinians deal with conflicts, through time. And probably, there's still a culture of dialogue here that is very strong. So we dialogue. And I told you about mate in a conversation that we have. And that is something that is very Argentinian. It is a drink that we share. And that is a way of bonding. And probably if you have a conflict with a friend or even a coworker or even within your family, you can ask them, invite them for mate, and then you can talk. And through mate, through share mate, that now we cannot do that because of COVID, but each one comes with their own mate to the meeting. You can talk and come up with a satisfying outcome for both parties, because mate brings people closer and it gives a feeling of how do you say, down to the tension, you know? When you have mate between you and other person, there's no tension. It feels that you know that people, you can start a conversation. So that is something part of the culture of Argentinians. What can I say about dialogue? We talked.
So does that translate into less number of cases in the courts? I mean, or is there a lot of litigation in the courts?
Yes. Courts here of us, I think, in the world, but I told you before that are crowded and that are still crowded. And sadly, COVID-19 kind of exposed that situation about courts in a more, widely manner. And also, courts were not ready for the virtual scenario. And that is why I highlighted that resolution that allowed mediators to work virtually through the pandemic, because the courts were closed. And that was a huge window, a huge opportunity for mediation to position itself in the community as an alternative when courts were closed. Well, you can still go to another space to solve your conflicts, and that is much more amicable and quick and cost-effective, probably, for this sort of conflict. There are certain conflicts that still need to go to court and justice. I think we all agree in that. But yes.
Okay, so what we'll do is we'll take extension from Vasiliki. Vasiliki, are you going to give us extension for 5-7 minutes?
Of course.
Okay, thank you. Because she started a little late. Her presentation started a little late. So perfect. Thanks.
Oh.
So basically now what I'm saying is that they say the community level, do we have some structure there in terms of mediation?
Here we do not have community mediation as was explained by Diana, that she explained community mediation perfectly. Well, in Rafaela, there is not, in my city I'm talking, there's not community mediation within the executive power of the city, within the city council. There's not. There is community mediation in the ombudsman office of the province that has like headquarters here. But sadly, and I don't want to offend anyone, but we do not know about its work and how much people is turning to that office. People probably go to the consumers defensory. They have that office really in mind because they had done a huge promotion of that office, for example. So people are familiar with, I have a consumer issue, I know where to go. But they are not that familiar with the ombudsman office in the city. But we do not have community mediation. We do not have community mediation in the neighborhoods, the center. The neighborhoods each neighborhood has its center, they do not have community mediators there
Okay,
in my city.
Okay, before we go further, German Barbieri has also given a thumbs up. So you can.
Another friend.
Okay, so your friends are watching and they're giving you thumbs up. So
That's
nice.
Yes.
But
yes.
because the
With friends.
yeah, but look, you know exactly how I've gone about it, because I look at it from the colonization perspective. So have you given a thought to that how colonization has affected dispute resolution in Argentina?
I don't feel I'm capable of answering that.
Okay,
you know,
perfect.
of going so back in time. No.
No, because what we're looking at is that there is a certain mindset, a psyche which has developed around the court system. So do you see that kind of a psyche that, like you said, that dispute resolution has to happen in courts? Do you see that kind of thing around you?
Oh, again, can you ask me again? I
like that basically dispute resolution is totally associated with courts.
Yes.
That seems to be a colonial aspect that we have picked up. So do you see that around you? So you see that feeling that, okay, we have to go to that authority like judge. Do you see, I mean,
yes, because I think there is a mindset that is really rooted in the community that the judge is the ultimate authority, and that the judge is the one capable of telling you how to solve your conflict, what you should do. And I don't know. I'm debating here. I'm reflecting. I'm not stating anything, but probably that's because that Immanuel Kant's sentence kind of, reflect on me. It made me reflect because probably is comfortable, probably is easier having someone to tell you what to do and have a loser and a winner. And that probably gives you some prestige among your peers. So that's something that probably I should get into, because all what I'm saying is what I think and what I experience as an attorney and as a mediator, and what I discuss with my family, with my friends about the perceptions of justice. So I think that is the culture, the mindset that has been developing. I don't know the relation with the colonial, I don't know if that is related. What I know is that the judge has a huge impact in the community. The judiciary is that power that you go when you want to be told what to do, and when you want to be told that you are right. But also people do not see judiciary as something human or even closer to them. They see it like far away, and they actually are frightened. They fear the judiciary. Going to court for people is a really stressful experience. So it's kind of contradictory. I don't know, but probably because that culture of you can solve your own problems, you can come up with the solution, you can talk. That is something that has to be fostered, that has to be practiced, and that should happen in the earliest stages of life, at school. That's the way of making a change.
Yeah, exactly. I mean, I'll come to that. Before that, Rodolfo Zehnder. Zehnder, how am I pronouncing it all right? Rodolfo Zehnder. Zehnder?
Yes, Rodolfo Zehnder, yes.
Okay. And there is
another friend.
Ines Bonis. Ines Bonis. Am I pronouncing this word name? Ines Bonis says Buenesimo. Okay. So they're all there. Your friends are all there. They're watching you and they like what you're saying.
Yes.
But why? I'll tell you why I keep coming to this is because if you have to create that culture of mediation, we have to go into that history to understand and change that mindset that things have changed. The colonizer has gone. The law, whatever. I don't look. I keep. You've heard me so many times. In India, we still kept the same civil procedure code that the British gave us. So have you changed that? Have you got new laws there on that?
On the procedures, on the court proceedings? Yes, there have been some changes. So it's changing, but it is a slow change, and there are still so many challenges. I don't want to be, rude or unfair to say that the judiciary is doing all wrong, because it's not accurate. It's not true. Things are changing, but there's still so much more to do to change mindset, because judiciary had like a history, as I said, to be like not friendly. People come there and nobody tells you, nobody says even hello or treats you in a proper manner. That has changed a lot. I can't say that people are in general rude. That's not true. And judges are changing because of all the human rights paradigm. That helped a lot, because now they have to be familiar with the human rights instruments, because our civil and commercial code of the nation that rules for the whole country, incorporated in Article 1 specifically human rights instruments. So this is important to stress, because this is the major change in terms of legal aspects in the country. The Civil and Commercial Code changed in 2015, and the previous code was from the 1800s. So, okay, so that it was an important, a huge reform on the substantive legislation for the whole country, and it incorporated the human rights perspective. So now judges on civil and commercial issues where the national constitution here, human rights are here, and we are here because we have this civil code. Now they cannot say that anymore, so that is kind of bring together, and that kind of change the way they solve the sentences, not sentences, sorry, the rulings, that has changed, because now they cite instruments, international instruments on human rights. Some judges did that prior to the civil code reform, but now they have to, and that is an important change on the mindset. Yes,
that's exactly what I'm saying, because if these things were continuing, that whole mindset seemed that you're still living in those times. So I think these are the changes which are required. So basically now, Liliana, of course, your last concluding remarks as to how you see the future of mediation in Argentina, what you are going to do about it, where you're going to take it, please.
Okay, so of course, I see a great future for mediation in Argentina. There's actually been a lot has been done. And as I said, I think the pandemic has opened a huge opportunity for mediation. And also we have a university here in my city, and I'm proposing an investigation of mediation, and that aspect that you mentioned is one that we are going to address to see how we can change why that mindset is so installed in society and what we can do to change it. So, but I think it is changing. It is slow change, and we need to, we talk about promotion and we think like big campaigns, but that is necessary, of course. But, talking to your friends and telling them, I'm a mediator, and they ask you, what is mediation? So that is when I found out that people do not know what mediation is. And they have, of course, the judiciary as this big institution, because it's rooted like millions of years ago. The judges existed before, I don't know if before mediation, because you stress in this symposium that mediation has always existed, and that is true. But as institution, the judiciary is prior. So that is so rooted. So I think talking about it, on a daily basis and keep practicing in the best way that I can, that is what I'm going to do personally, and keep researching. And I hope for a great future for mediation here in Argentina, because I think COVID-19 has changed all human interactions, and why not the interaction with the judiciary? People need another form of justice. People are seeking for another ways of reaching justice. We need everything immediate, instantly right now. Everything is dynamic. So justice should be that way. So people are reaching and are, there is a crisis and we have to take it as a huge opportunity.
Because interestingly, Liliana, yesterday I recorded this session from this people from India doing interesting work in developing. They've created a online platform and they're doing amazing work on that. So now they've reached the 1 million mark. They've already done 1 million cases on that platform. So how this young girl, this group of young law students, I think they only graduated some 1 or 2 years back, and they've developed this entire platform. So you must watch that, how they went about it. Like she was telling us how they were walking on the streets into cafes and everything, telling people about mediation. They attractive.
Yeah.
And she said,
Yeah,
I was sitting there playing some song, singing some song just to attract people and then tell them about mediation. So watch that session. Watch that session. And
I will. I promise I will. Thank you.
That's Akshata is her name, and with her there was Sachin's of course looking at some on the policy, on the larger things, creating an environment for these young people to do things. So very interesting work is happening there. So thanks a lot, Liliana. Always a pleasure talking to you, and definitely we'll continue our conversations on this. Yep.
Thank you so much for inviting me. Thank you, Giovanni, for being there. Thank you, Basiliki, and sorry for taking some of your time. And thank you all that listened to my presentation. Thank you so much. Gracias.